another very interesting and important topic from the point of view of UPSC, general anti-avoidance rules. This comes under the economics section, and why it is in news? Because GAAR, General Anti-Avoidance Rules probe begins on companies suspected of tax avoidance. This was taken from Economic Times. Okay. So now the Department of Revenue, Ministry of Finance, has initiated GAAR probe on the companies suspected of tax avoidance. Now, what is tax avoidance? What is tax planning basically? There are three kinds of tax planning that can be done. The first one is tax evasion. Tax evasion is a criminal act. Tax evasion means, tax evasion means not paying the tax. Not paying the tax. Okay, and that is a criminal offense, right? Tax avoidance. Tax avoidance is using some of the loopholes. Okay, is tax avoidance is using some of the loopholes to avoid paying taxes. Okay, to avoid paying taxes. It is not illegal. It is not illegal to avoid taxes if you find a rightful loophole in the law. But when companies plan aggressive tax avoidance, that leads to loss of revenue to the tax revenue to the government. In such cases, what government has done, government has brought two specific laws, basically SAAR and GAAR. This is called specific anti-avoidance rules. This is called general anti-avoidance rules. These were present before these came later. So we are going to study about GAAR. Now, if we look back at this diagram again, this was taken from Pricewaterhouse Corporation's a document. I believe you should read this. Now, tax evasion, tax avoidance. Tax evasion is evil. Tax avoidance is good. Not good. It's not ethical. But if you find a loophole into the tax law, then you can avoid paying taxes. But it is legal unless a company is aggressively avoiding paying taxes, which could lead to loss of revenue. In that cases, to avoid that, government has provided these, and we'll be studying about them. The third important point is tax mitigation. Tax mitigation is using some fiscal incentive to avoid paying taxes, like investing, okay, donation, and all. These can be used as fiscal incentives, okay? Because if you are investing in some scheme after which you get some tax incentive, so that is good. That is a positive thing. Tax mitigation is a positive thing. Tax avoidance is not good naturally, but you can avoid some tax, and tax evasion is crime. So tax evasion ke liye you will be punished. So these are three kind of tax planning that usually individuals and companies do. Now, again back to avoidance. Avoidance means avoiding paying taxes by finding out the loopholes into the law. So law cannot have very tight boundaries or watertight boundaries for every specified case. Okay? So what generally happens is government, after making a law, provides some kind of rules. So specific anti-avoidance rules. Specific anti-avoidance rules were those rules which were specified for a specific act or a specific avoidance tax provision. For example, a company is avoiding paying taxes through using some specific method. So government found out that method and issued a rule against that. That means you cannot, if you are using this route, so this comes under SAR and you will be prosecuted. You will be treated as a criminal. तो SAAR में बहुत सारे provisions थे, है ना? तो ये provisions specific provisions थे for specific crimes, not crime, for specific avoidance policies. Then in 2012, GAAR were for the first time brought into the into the law. Okay? But it became effective in 2015, after 2015, 2016, and in 2017 basically, and they have been effective now. So where SAA are specific laws, these laws are general. These rules are general anti-avoidance rules. Okay? So if, for example, if you are using some specific method to avoid tax, the tax authority, okay, the tax authority can penalize you. But this specific rule also does not have all the provisions of avoiding tax. So government later issued GAAR, General Anti-Avoidance Rules, which are not specific in nature of the transaction, but they set out some general laws, some general criteria to determine if a transaction is done to specifically avoid paying tax or not. If your transaction is done specifically to avoid paying tax, then you will have to pay tax and fine also. So these are basic. This is the basic overview of GAAR and how tax planning is done. Now, what is GAAR? Rules that apply to companies to prevent them. Okay, very important point is that GAAR, General Anti-Avoidance Rules, are under IT Act in Income Tax Act 1961. They are present in Income Tax Act 1961. Okay. So general anti-avoidance rules are the rules that are applied to companies to prevent them from doing aggressive tax avoidance. Aggressive tax avoidance. Okay. Aggressive tax avoidance means a lot of, if the company plans a lot of tax avoidance by finding a lot of loopholes, then that is leading to a loss of revenue to the exchequer, and that needs to be penalized. These were brought in 2017. Okay, there is a framework called OECD BEPS, that is Organization for Economic Cooperation and Development, Base Erosion and Profit Shifting. This is a framework. Framework and law are different. Law is legally applicable, and if one is not obeying the law, then they will be made accountable under the courts. A framework, on the other hand, provides a specific outline or specific direction to make a specific law. OECD means Organization for Economic Cooperation and Development. Okay? OECD have formulated base erosion and profit shifting framework. Now, what is BEPS? We will be like we can write it down. BEPS, base erosion and profit shifting. We will be understanding it in a while. Okay? GAAR was initially proposed in Direct Tax Code 2009, although it was introduced in Budget Session 2012. Okay? A committee under Parthasarathy Shom, this is important point from the prelims point of view. Parthasarathy Shom Committee or Shom Committee was set up in 2012 to review the proposals that were brought for GAAR, which the committee proposed that the implementation of GAAR should be postponed for at least 3 years, so that the tax authorities can come up with some specific infrastructure to implement those rules, and that is why it was postponed. So in 2015, what happened? In 2015, okay, 2012 में this Parthasarathy Shom Committee recommended कि it should be deferred for 3 years. In 2015, to be base erosion, profit shifting, this framework was brought by OECD. ठीक है. अब and then after 2 years, in 2017, general anti-avoidance rules were brought in India. This is how the evolution of this GAAR took place. Okay. So GAAR is nothing but a law, a very specific clause under IT Act, Income Tax Act 1961, that helps the tax authorities to prevent the tax avoidance by the companies in an aggressive fashion. Okay. Now, how companies offshore their profits? Tax havens, subsidiary holding companies, transfer pricing, and arm's length principle. This is what we are going to talk about in this slide, and this is going to be very interesting. How? तो बी OECD, ठीक है, OECD BEPS, ठीक है, this is one term, OECD BEPS. This is called base erosion, okay, base erosion and profit shifting, okay, base erosion and profit shifting. Base erosion means erosion of tax base in one country. Profit shifting means shifting of profits to other country. Shifting of profits to other country. This is going to be very interesting. You are going to have understand how these large multinational companies offshore their profits. A very basic example is about Google. Okay? So Google is like Google, Apple, and all these multinational companies. They are using a lot of tax havens to offshore their profits, and we are going to understand it how. Now, what are tax havens? Tax havens are those countries which have 0% tax rate on capital gains. Okay? Capital gains tax is very low. Okay? Capital gains tax is very low. Now, subsidiary holding companies, these are basically shell companies. Okay? Now, what is a holding company? Holding company is a company which does not do any business, but it holds shares of another company. Okay, these are called holding companies. Okay. Now, what is transfer pricing and arm's length principle? We will be dealing with them in a later point. Okay, so I hope you understood up till now. Now we are trying to understand how companies are avoiding paying taxes. For example, a company is registered in USA. Okay? There is one country, Ireland. Okay? There is one country, Ireland. Ireland is having a very low tax rate, for example, for 3%. Okay? They are having very low tax rate of 3%. In USA, the tax rate on capital gains is 35%. The tax rate on capital gains is 35%. Now, MNCs like Google operate throughout the world, right? They operate throughout the world. Okay? For example, in India, they are operating in India. So there is a Google India, Google USA, and Google Ireland. Okay, understood? Now, there is also one other company, Google Holdings. Google Holding, that is also in Ireland, right? Fine. For example, now Google's main revenue comes from ad business. Okay, ad business, right? For example, some user makes a purchase, okay, makes a purchase from Google, okay. So when you are purchasing an ad on Google, you are not basically paying to Google India, okay. You are making a purchase from Google USA, okay. So for example, if you paid rupees 100 for that ad, yeah, if you paid rupees 1000 for that ad, okay. So Google USA is the original company that you are paying to, right? Now Google USA, now there is one company called Google Holding. What Google Holding does, Google Ireland, now another company is Google Ireland. Okay? Now Google Ireland is a company which holds licenses, softwares, ठीक है, licenses, softwares, intellectual property, ठीक है, all the and another other such important things that are important to run Google, right? And Google Ireland is held by a company Google Holding which owns the Google Ireland by 100%. ठीक है, that means Google Ireland is a company जिसकी ओनरशिप किसके पास है? गूगल होल्डिंग के पास है, 100% ओनरशिप, राइट? नाउ गूगल यूएसए आपने परचेज तो किया एड गूगल यूएसए से, राइट? और आपका एड रन किया, आपने ₹1000 पे कर दिए गूगल यूएसए को. नाउ वो एड रन करने के लिए व्हाट विल गूगल डू? Google will make a purchase from Google Ireland. Google USA will make a purchase from Google Ireland, a license. They will purchase a license. ठीक है? लाइसेंस कैसा? वो लाइसेंस ऐसा होगा कि वो स्पेसिफिक एड रन करने के लिए जरूरी है, ठीक है? या इंटेलेक्चुअल प्रॉपर्टी, एनीथिंग दैट इज अ सॉफ्टवेयर, राइट? तो दे विल मेक ₹800 पेमेंट टू गूगल आयरलैंड for purchasing that specific license to run an ad, या specific software to run an ad, because Google USA does not own anything. It just has an office and programmers and all, they are coding and doing all the things. On the other hand, Google Ireland owns all these intellectual property and the Google holding company holds all the ownership of the Google Ireland. Now if all this was situated within USA, so USA will be taxing this transaction. Now the the tax is on the profit, long term on a capital gain, ठीक है? तो actually Google USA should pay a 35% tax on ₹800 to US government, ठीक है? What Google USA should do? They should pay, because they are earning ₹1000, sorry, they should pay 35% of ₹1000 to US Treasury, US government. But instead what they do is they offshore this ₹800 to Google Ireland, ठीक है? जहां पे टैक्स रेट कितना है? 3% या 1%, ओके? तो ₹800 ट्रांसफर हो गया गूगल आयरलैंड में, वहां पे टैक्स है फॉर एग्जांपल 1%, तो ₹8 ऑफ 800, ठीक है? 800 का 1%, ₹8, तो दे विल बी पेइंग अ टैक्स ऑफ ₹8%. They will be paying a tax of ₹8 on a transaction of ₹1000 in Google in Ireland, ओके? तो यहां पे क्यों इन्होंने परचेज अपनी ही एक होल्डिंग कंपनी, एक सब्सिडरी कंपनी को ₹800 ट्रांसफर कर दिए इन द परचेज ऑफ लाइसेंस टू रन दैट स्पेसिफिक एड. अब यूएस में इनके पास कितने बचे? ₹200 बचे. अब इस 200 पे 35% टैक्स पे. अब ये 200, सॉरी, दिस 200, अब इसमें ऑपरेटिंग कॉस्ट, रनिंग कॉस्ट, ये सारा काट के ₹150 इनके पास बचता है. इस 150 पे 35% टैक्स पे कर देंगे, बात खत्म, ओके? दिस इज व्हाट दे विल डू. तो दे विल पे 35% ऑफ 150, so that the capital gain of USA company will be only 150 out of ₹1000, ठीक है? And majority of their money is untaxed because of the presence of tax havens. This is the method how companies offshore their profits. Now what is transfer pricing? Transfer pricing, like I said, कि जो Google USA है, it is purchasing license from Google Ireland, ठीक है? It is purchasing from Google Ireland. In that purchase, it pays ₹800. So this is transfer pricing. Transfer pricing means when two subsidiary companies of one major company make transactions between them, so the cost, the price at which they make the transaction is called transfer pricing. ठीक है, transfer pricing. So this might be, the original cost might be 100 rupees only, but they can set the transfer price between themselves to 800 rupees, so that the money left in USA is very small, है ना? So this is called transfer pricing. Now second is the arm's length principle. To avoid this exorbitant price between the subsidiary companies, what governments do is they prescribe arm's length principle. It is also under BEPS, Base Erosion Profit Shifting Framework, ठीक है, जो OECD ने इवॉल्व किया है. उसके अंदर क्या है? Arm's length principle says that Google USA and Google Ireland, or any two companies of one company, any two subsidiary companies of one company, should transact between themselves as if they were transacting with a company outside of them. Like, they should make this transaction in such a way that Google USA was actually transacting with some other company, not a subsidiary company. Because when it is making a transaction with some other company, so it will try to reduce the cost, right? That will be the aim. But here the aim is to increase this cost so that most of the benefit could be transferred offshore. So that is called arm's length principle. So this is how these companies are avoiding paying taxes in many tax jurisdictions because of the presence of tax havens like Panama Islands, Ireland, Bahamas Islands. Okay. To prevent this, like there was a very important case, Vodafone tax case in India. ठीक है? ठीक है, तो Vodafone tax case in which actually Indian government lost a lot of money, ठीक है, recently. तो in 2009, after the Vodafone tax dispute was filed, so this provision was brought, but these provisions became an act only in 2017. So GAAR provisions are made to restrict the companies from planning aggressive tax plan avoidance. ठीक है, तो any transaction that is being done between the companies will be considered the violation of general anti-avoidance rules if it has these four elements. Okay, and if the presence of these four elements is demonstrated, then the tax authority, basically the Indian tax authority, they will declare the transaction IAA, impermissible avoidance agreement. ठीक है, for example, if two companies are making a transaction between themselves and that transaction contains these four elements, ठीक है, या either of these four elements, then the tax authority of India, basically income tax department, can flag this transaction as impermissible. This is what the whole term is. They can, in IT department, income tax department, can flag the transaction if the transaction has these four traits. ठीक है, what are these? Now, if the primary condition is main purpose to obtain, if the transaction between the companies is done in such a way that the main purpose is to obtain tax benefit, like Google Ireland and Google USA, ठीक है, and the four tainted element test, तो अगर ये चारों टेस्ट पास हो जाता है कोई ट्रांजैक्शन, तो it will be okay. If that transaction fails either of these four conditions, then that transaction could be provided impermissible and tax will need to be paid. ठीक है, the first condition is creation of rights or obligations that are usually not done in the commercial transaction. Like, if these two companies are making a transaction and some specific rights or obligations are created through this transaction which usually would not have been done, so that will amount to be a failure of GAAR. results directly or indirectly in misuse or abuse of provisions of the act. Okay, तो जनरल एंटी अवॉइडेंस रूल्स के वायलेशन में है. Lacks commercial substance. Okay, sometimes the commercial substance can be missing and only a tax avoidance transaction is done. ठीक है, and is entered or carried out in a manner ordinarily employed for bona fide purposes. अगर कोई स्पेसिफिक प्रोविजन या एग्जेम्पशन गवर्नमेंट प्रोवाइड करती है और अगर कोई कमर्शियल ट्रांजैक्शन उस स्पेसिफिक एग्जेम्पशन का यूज करके किया जाता है, सो दैट it should avoid the tax, it can gain a tax benefit, so that can also be termed as a violation of GAAP. Okay, so such transaction should be declared impermissible avoidance agreement. That is, such transaction cannot be permitted and the tax on these transaction has to be paid. Okay, again to provide some safe harbor. ठीक है, ऐसा नहीं कि सारे ट्रांजैक्शन ही टैक्स अवॉइडेंस के लिए हैं. टू प्रोवाइड सम safe harbor rules also apply. A quantum of tax below 3 crore, if the transaction involves a quantum of tax that is below 3 crore, so it is safe, it will not be flagged impermissible. Arrangement involving certain transactions for institutional investors. Okay, FII with certain predetermined FIIs that has been flagged as, that cannot be flagged impermissible. And arrangements entailing income accruing or arising to a person for transfer of an investment made before April 2017. That means it will not be applied retrospectively. It will not be applied retrospectively. For a transaction done in the past, prior to the application of these rules, it will not be applied. Okay, so these are the safe harbor rules. Procedure for invoking: the tax officer may examine the transaction, then the commissioner for income tax will take the opinion, that will make the opinion if the transaction is impermissible or not, and then approving panel, a panel within the CBDT, the Central Board of Direct Taxes, they will make a recommendation, and they will, if they believe yes, the assessment by the tax authority, tax officer and commissioner of income tax is correct, then they will approve the transaction as impermissible avoidance agreement. Okay. Redressal mechanism, remedy under the act. So income tax appellate tribunal is there for direct tax disputes, and a person who believes that his transaction has been inappropriately flagged as impermissible, he can approach ITAT, or if he is not happy with the decision by ITAT, he can approach High Court or Supreme Court on the constitutional remedies also. Okay, so I hope you understood that GAAP is basically for preventing companies from making aggressive taxation planning, aggressive tax avoiding planning. ठीक है, so as you understood how companies are offshoring their profits and leading to base erosion and of course profit shifting. Base erosion in the sense that they are removing the tax base in the country they are operating, and profit shifting in the sense that they are taking away most of the profit that has been earned in that specific country to a tax haven. Okay, and thereby making a lot of tax benefits. ठीक है, so GAAP, I hope you understood. It was very interesting for me. I believe it was interesting for you also. So if you have any queries regarding this, kindly reach me out in the comment section. Okay. And for the last topic today, we are going to look at the Lancet report on pollution.